What's up, LinkedIn? This is Hillary, and I'm here again with Andy Mendelson, Chief Risk Management Officer for Berkeley Design Professionals, as well as an architect. Today, we're going to be talking about the indemnification clause in design professional contracts. The indemnification clause is a common contractual risk shifting mechanism, and I think this is one of the first clauses that was always tweaked and always discussed the most in design professional contracts. It's definitely evolved over the years, and it's certainly not the only contract clause that needs to be reviewed and scrutinized a little bit. But we're going to talk about this clause and what design professionals should look for when reviewing contracts. So Andy, do you want to go ahead and talk a little bit about the indemnification clause?
So what does indemnification means? It means you're assuming a specific liability in the event of a loss. A design professional is legally liable for the damages caused as a direct consequence of its negligent act or omissions, which is exactly what is covered by your professional liability insurance policy. But it needs to be fair and insurable, and your client is really the only one who can benefit from the indemnity. When they start adding related parties and agents and contractors, you can't do that. So you're doing it directly for the benefit of the property owner, assuming that's your client, and its defined representatives only. It has to be based on claims that arise from third parties, and it also needs to not include the word defend. So because providing a defense prior to a finding of fault is not insurable under PL policies. It is possible though while we're not going to provide an upfront defense, you can include the obligation to reimburse your client's attorney's fees and expenses if it is determined at the conclusion of the dispute resolution process that those are in fact the design professional's responsibilities. It really starts with the go, no go process when you're evaluating the project and the client. What do you know about the client's litigation history? Have they filed suits previously against architects or engineers or contractors? Are they a litigious client? Are they fair in dealing with contracts? One of the excellent phrases that one of our outside counsel provides to us is, if you put the phrase at the beginning, to the extent coverage is provided to the design consultant through its insurance policies required of this agreement, comma, and then just whatever the owner wants to say, that's going to pull the professional liability indemnity obligation within the context of the professional liability insurance policy.
Switching gears, still on the indemnification clause, but so much that relates to the professional liability policy. What about on the general liability policy? Any thoughts or comments on that as with contracts and getting some coverage there?
Well, I'll start with a comment that I'm not a general liability expert, but sure. My understanding is that the general liability policies are more liberal in terms of their approach to providing an upfront defense of a claim. This is why in contract, we always want the architects, engineers, other design consultants, and the owners identified as an additional insured on the contractor's commercial general liability policy, the CGL policy. Because if there's an example, a worker injury or a property damage that's caused by the contractor, you can tender that claim to the contractor's CGL carrier, and in most cases, they will step in and actually provide the defense.
Sometimes a design professional can have, the perfect contract, or, they've all the right amount of liability within their contract, and they've had it reviewed by their attorney, they've had it reviewed by, their insurance carrier, and they're still brought into a claim.
Understand the contract that you have signed. Don't just stick it in the file and not be known as to the key aspects of it by your project team. So our recommendation is the project principal and the project manager, who should be intimately familiar with the contract, share the key aspects of it with their project team. And the goal here is to perform your services consistent with those contractual obligations that you have. In other words, if you have an agreement to review shop drawings within 10 business days, make sure you review those shop drawings in 10 business days. If you have normal responsibilities during a site visitation, make sure you perform your services in accordance with that site visitation and don't start stepping over the lines into means and methods of construction or site safety or that sort of thing. If you're obligated to provide 3 options for schematic design, provide those 3 options in schematic design. Hopefully you've gotten fees to do that, but don't provide 2 and go on with the project without any documentation that your client was satisfied with those 2 options.
That's why it's important to have somebody that's, taking a big role with that niche with architects and engineers, so they understand what to look for and can provide you the resources and help do the review and get you in touch with top tier carriers like Berkeley, so that you can try and avoid, risks that are unnecessary. So, all right, thank you so much, Andy, and stay tuned for next time.